Hi, this is Lisa DeMonte from mylegal.com, and today is October 4th, 2010, and we're here in Washington, D.C. at the Ronald Reagan Center for the first day of the Masters Conference in Washington, D.C. And with me this afternoon is Barry Wiggins, who's the Director of Forensic and Dispute Services Practice with Deloitte. Barry just served on a panel entitled Possession, Custody, and Control in the Cloud. With him on the panel was Mike Lackey of Mayor Brown. Welcome, Barry. Thanks for joining us.
Thanks so much for having me.
Thank you. Barry, what are the key takeaways from the panel discussion this afternoon related to the cloud issues?
Sure. I think the most important takeaway or headline that you would have is that if it's your data, it's your problem. So in that regard, even though you might well be using a service provider for the storage of information, if a court legally can determine that it's your data, and by that means you control that information with some practical ability to access it, you then have obligations to preserve that information in litigation and will likely have obligations to retrieve it in litigation in a particular matter. So that would actually be, I think, the first and foremost thing I would think of. Secondly, given that, you need to think about how carefully you can establish your cloud computing relationships with your service providers, bearing in mind that you might very well be called upon to work with them, and potentially closely with them, in responding to in a discovery dispute or governmental investigation, where you will both have to coordinate your efforts to provide information to the other side.
Barry, to that end, related to your comments about the key takeaways, do you feel that the bar is actually being raised in terms of the responsibility that attorneys have with respect to dealing with all of these very difficult and uncertain issues related to the cloud?
No, absolutely. Yeah, I think we've seen a growing trend in the law for courts holding lawyers more and more responsible for having an understanding of electronically stored information. We certainly have seen that in the growing number of cases post the amendments to the Federal Rules of Civil Procedure. And those responsibilities are going to vary and grow as the technology varies and grows. The bottom line is going to be that as an attorney, you're going to need to have at least a basic understanding of how and where your client keeps information and how and whether that information can be retrieved in a dispute context.
So much like e-discovery, ignorance is not going to work.
Absolutely not. Courts are more and more every day are saying enough's enough, it's your obligation.
Barry, thank you so much for joining us this afternoon. We appreciate your taking your time to chat with us.
Thanks so much.
Have a great afternoon.
Thank you. You too.